I'm here with Martyna from a law firm in Poland. I am a partner at IMD Solicitors, and I head a family department at IMD. And together with Martyna, we deal quite often with cases with international elements. We have to make decisions and help our clients make decisions about where to issue court proceedings. Martyna, thank you for joining me, and thank you for accepting the invitation to discuss those issues.
Thank you for the invitation. So my name is Martyna Dudkowiak. I am an attorney at law in Poland. I take care of family and divorce cases in Poland, especially with a cross-border element. We cooperate with Iwona with several family cases. And I think that it's a very good idea to help our clients to how to decide which jurisdiction would be better for their cases.
How does it work in Poland, Martyna? How do we start? How do we go about issuing proceedings?
Okay, so in Poland, a divorce petition may be filed only in writing to the competent court. It is not possible to submit a divorce petition online, which I think is a huge disadvantage right now, as everything, well, almost everything can be done online. And what's more, in Poland, there are no divorce petition forms, although the structure and the formal requirements of the petition are specified by the law. So in Poland, the divorce petition should include the designation of the court to which it's addressed, personal data of the parties, so of the spouses, precise description of the request, and justification of those requests. So those are the basic, the most important requirements for the divorce petition.
Okay, so I think to the contrary, in the UK, we are able to use online portal and issue petitions online. We don't do paper applications anymore, so everything is digitalized. And I think there are also traps with it, because on the face of it, it looks like it's very simple and everyone is attempting at least to go through the process, and the lawyers are engaged when there are complications. But I think that's really important to, first of all, especially in cases where you have assets in various jurisdictions or any international elements to your cases, to consult before you do anything. Even if you decide that, okay, I can file the petition online myself, please remember to discuss that with the lawyer. I think another very common question when it comes to our inquiries from our clients is, how do we go about default? Can I ask for default and for someone to be blamed for the divorce? How does it work in Poland?
Yes, well, in Poland, the court in the divorce decree will decide about fault for marriage breakdown, and it follows from the law provisions. No fault divorce is an exception and may be granted by the court only upon joint request of both of the spouses. A divorce based on fault involves the obligation to prove the guilt of the other spouse. And to prove fault, it is necessary to provide the court appropriate evidence, for example, list of witnesses to hear. We can use also private detective report or other documents related to the other spouse misconduct. Divorce proceeding based on the fault judgment usually take much longer due to the need to conduct this precise evidentiary procedure, especially to hear all the witnesses requested by both of the parties. So at the end, the proceeding may take a few years. The fault indication may be important for one of the spouse because the main consequence of the divorce based on the exclusive fault of one of the spouses is the obligation to pay the maintenance for the former spouse after divorce. So the rule is that the maintenance for the other spouse may be awarded if one of the spouses is found solely guilty and the divorce entails a significant deterioration in the financial situation of the innocent spouse. So the disadvantage is that the proceeding will for sure last much longer. But on the other hand, if the innocent spouse doesn't have his or her financial situation is not very good, it may be worth to consider to request a default indication.
So we don't have that same powers in the UK. We don't consider the default within the divorce proceedings. And we used to have an option to rely on unreasonable behavior of the other side in the past prior to change in legislation. And I think it's also connected with the fact that the financial matters are separate to the divorce. And if you want to draw the court's attention to someone's conduct, you can do that by a separate application in your financial matters division of assets case. So you can make the court aware at the very early stage of the division of assets case that you think that the spouse's conduct and behavior should be taken into account, and then the court may list it for give specific directions in terms of statements that have to be produced, and we can then consider whether that conduct should be actually taken into account when it comes to division of assets. I think I would want to discuss the way the courts approach the proceedings and what can we deal with, what can be considered by the judge within the divorce application itself. So how does it work in Poland?
Well, in Poland, the divorce decree may be quite complex if the spouses have common minor children. So at first, of course, the court would decide about the divorce, and the court shall rule on on default for the breakdown of the marriage. And the only exception is no fault divorce. But only in case if both of the spouses will file joint request for no fault divorce. Then, if the spouses live in a joint apartment, the court in the divorce decree also decides on the manner of using this apartment during the time of joint residence of the divorced spouses. And then, if, as I said, spouses have common minor children, the court in the divorce decree will also rule on parental authority over minor children, about child support, and about contacts with children after the divorce. And here, regarding the contacts, we have also an exception. Well, upon joint request of both of the spouses, the court will not regulate the contacts, but a rule is that there should be a contact schedule.
Would the court still consider children matters relating to those children if one of the party objects and says it's not appropriate because children living in another jurisdiction?
Well, basically, it depends on the law provision which would apply to the case. So it depends where the party lives. So if we have to, if the Polish law provision applies, or we should use some European Union resolutions. So it's hard to give one good answer. But I would say that I will, based on, for example, Polish law provisions, if there is a jurisdiction to recognize divorce case in Poland, the court will also decide about children matters, even if in a separate case, a Polish court doesn't have the jurisdiction.
In the UK, in terms of the divorce case, we do have three separate matters, one for children, one for divorce, one for finances. They don't usually, you have to run three separate cases, but they're still dependent on each other. So when you're making an application to court to decide your finances, you'd have to wait until a certain point in your divorce case to be able to do that. Your final order in respect of division of assets would not be enforceable until your divorce case is finished. And I think the reason why the courts in the UK consider those matters separately, I think it's also to do with efficiency, because not every case, for example, not every couple would need an order in respect of children. They're able to regulate contact and custody without the involvement of the courts. So I think it's saving a little bit of time in that respect, and we've got some delays as well when it comes to dealing with especially children matters. But every element of the divorce is actually considered separately. But the outcome of the children arrangements, for example, may impact the decision in respect to finances, especially when we're talking about modest assets and smaller estates when it comes to the division of assets. I think one last question for today that I would have for you and for myself really is where do you think we should be issue, which jurisdiction is better where to issue proceedings?
There is no one good answer. I think that it depends on the circumstances of the case, of the situation of the family.
So there is no one answer, but one is certain: we do have to look carefully at the possible consequences of issuing in either jurisdiction before a decision is made. So if you're in a situation that you unfortunately dealing with the breakdown of the relationship and need assistance in either jurisdiction, please get in touch with us and we hopefully will be able to guide you through the process.
Thank you.